Thank you to Baroness Faulkner and Mr Kirkpatrick for being here today, and thank you for all your work over recent years. I want to take a moment really to think about the impact on women and girls, actually. So it is clear that many organisations have breached the Equality Act going back many years. What approach will you be taking with respect to these historic cases where women and girls have been discriminated against to their detriment? And I'd be particularly grateful for your thoughts specifically on the many women who have lost sporting awards, medals and places unfairly, and what responsibility does the EHRC take with for that in light of the original guidance, which obviously is not in line with the Supreme Court ruling.
Yes, I'll ask John to come in because he'll have more concrete responses. But I just want to say that it is a sad fact, but it is a fact, that organisations, even regulators, get things wrong. And I should say that I am proud to have led a board and a senior staff team where, as we started realising that we might be getting things wrong as litigation came up, but also our own understanding of the Act. As the board changed and we got more knowledgeable members of the board who were prepared to question the orthodoxy that existed within the organisation, we realised that we were perhaps not in the right place. And we realised that as soon as the end of 2021. I had been in post for less than a year when we started a course correction. And, you know, as an organisation, I'm proud to say that we have been the ones who have led the course correction. Even the very fact of intervening in the Supreme Court judgment of itself was an attempt to correct the course. We are under Section 11 of the Equality Act, we have to advise governments when we think that the application and the enactments contained in legislation are creating difficulty, and we did so as long ago as April 2023. We started looking at that in April 2022. John, did you want to come in with
a little bit more on that, and then one
historic?
A little bit more on that, and then one answer to your latter question. As Kishwa says, the EHRC sought from 2022 onwards to put into the public domain in our guidance what we thought was a correct interpretation of the law as it was then. That was a move from what had previously been understood. Clearly, not only we, but also quite a lot of other people had got it wrong for a while, as the Supreme Court has now determined. Now that the Supreme Court has determined what it has, to your point, we have consciously taken the decision that our priority should be to try and bring some of the clarity through guidance that committee members and others have sought, and that's our first priority. We've started with the Code of Practice for Services, Public Functions and Associations. There is a lot of other guidance out there that will be affected by the judgment that we want to make sure is right and correct and in the public domain, and that will be our first starting point. Only once we've done that, we think, is it really reasonable for us to think about moving on to enforcement against current poor practice or current breaches of the law, and or potentially past ones. But it's a little further down the road, I'm afraid. We have, for reasons which I think are justified by this conversation, concentrated on trying to bring what clarity we can in the light of the Supreme Court judgment and move forward on that first.
Thank you for that, and obviously I'm pleased to see the course correction, and that actually you weren't afraid to recognise that an error had been made and you're looking to address it. That's exactly the right thing to do. I think the point that I just want to make today is that error has led to women and girls losing out on opportunities. I mean, it will have changed lives, potentially, that error, and it also has led the trans community to believe they had certain rights that they didn't. So I do think it has created damage. Actually, no one has won from this ambiguity, and it's really important. Obviously, we don't have that situation again, and it's really clear following the Supreme Court, which was a definitive ruling, both government and the official opposition are very clear on that, and that the guidance recognises that very clear ruling. Sorry, that was a comment, not a question.
Okay.